SJC-10773, Commonwealth versus Claudio.
Let's proceed.
Good morning. May it please the Court. Jeffrey Baylor for Mr. Claudio. In this case, Mr. Claudio was convicted of a first-degree felony murder. Armed robbery was the predicate felony. He was found to be a co-venturer with one William Santos, who was found to be the principal in this shooting. This Court has already heard Mr. Santos's appeal and reversed it, finding that, among other things, Mr. Santos's statements should have been suppressed because he requested an attorney and questioning continued. First off, we contend that just based on the dependence of Mr. Claudio's conviction on that of Mr. Santos, that his case should be similarly reversed. Because when the jury is looking at Mr. Santos as the principal, without finding him guilty, they could not find that Mr. Claudio was his co-venturer. Therefore, it could not be a harmless error if Mr. Santos was not properly tried.
But if the reasons that Santos's conviction was overturned have zero to do with Claudio, I guess I'm not seeing that.
Well,
the errors were peculiar, which I think they were. I mean, the two that I'm thinking of, the statement to the police and the Bruton issue related to the statement of your client.
right. Well,
But why is that? How does that have an impact on Claudio?
I think it is harmful to Mr. Claudio. But my first thing is just from logic of what the jury would have had to go through. They would have to first find Santos guilty as the principal.
Well, they could have done that if Santos wasn't even tried with him. I mean,
That's
there's no requirement that they be tried together.
That's true. And if they're tried separately, I think that's a separate case because the evidence comes in separately, and then whatever evidentiary problems have to be addressed separately. But in this case, the jury is looking at them both together. They're saying, A, Santos is convicted, he is the shooter. B, Claudio is working with him. So without A properly being, Santos being properly tried, how could Claudio be properly tried?
I take it that would be, in your view, any time you have two or more defendants tried together, if there is an issue that for which one conviction is reversed, the others automatically should be reversed as well?
Not if they, for example, if they were co-venturers and it's not clear who the principal was or the co-venturer was.
So this problem would not exist anymore post-Zanetti, in your view?
Well, I mean, I guess it would depend on how the jury was instructed. In this case, the jury was instructed that Santos was the principal, and that's what you can find. Claudio was the co-venturer, and that you could find. It wasn't like open to were they working together. We don't know who the shooter was. It was one or the other. Here, the jury was specifically told on the verdict sheets that Santos was going to be the principal and Claudio was going to be the co-venturer, and that's based on what the evidence was. Beyond that, we contend that Santos's statements that came in was also harmful to Claudio, aside from this just reasoning issue. This court found that Santos' statement was harmful because the police repeatedly said that Santos was lying, that it showed that Santos had been in prison, that he was a drug user and generally had bad character. It was based on the police questioning rather than what Santos actually said. Also, Mr. Claudio was mentioned by Santos as someone that he knew, and that police repeatedly, as it says in the Santos decision, the police repeatedly asked Mr. Santos if Claudio had borrowed the car that was allegedly used in this offense. So we contend that it would be harmful because the jury was likely to say, oh, Claudio was with this guy, he was a drug user, he was in jail, he was a liar, so Claudio must be the same. So again, we contend that it should be reversed based on this court's ruling in Santos.
Now, I don't hear you or read you to say that there was a Bruton problem to have Santos's admissions come in with regard to your client. So if you're not claiming that there's a Bruton violation, how are you going to claim that you're entitled to reversal?
I'm saying because this allowed, this court found that this allowed the jury to find that Santos was basically a bad guy. So
sort of guilt by association.
Exactly. They're saying that, so now the jury's saying, oh, he was with this bad guy, so he must be a bad guy too, and guilty.
But the logic of that would basically say that Bruton should be expanded to essentially include virtually every case, because the jury's not allowed to use the confession or the statement of Santos against your client, and you're saying that that's essentially inherent.
No, you're really focusing on the errors that
Yeah, I'm
affected.
saying, yes, but in this case, it shouldn't, since it shouldn't have come in, that's where the difference is. It shouldn't have come in because of the errors where, because Santos invoked his right to counsel. Beyond that,
And have we ever done that?
I didn't come across a case where it was done, but it just seems to, it seems to make sense that if Santos is found to be not properly convicted, and the reason was because these bad things came in against Santos that shouldn't have, that the jury is likely to lump him to Claudio together with Santos, and therefore he should get the same benefit of the harmful error. Beyond that, in Santos, this court looked at other evidence that might come in at a retrial and found that a certain prior bad act evidence was irrelevant. This is something that we also argued in our brief, that certain evidence relating to an incident that had occurred prior to the shooting should not have come in. Marquez, who was the getaway driver who testified under a plea agreement, was allowed to testify that on the way to this incident, he drove Santos and Claudio, and they stopped at the house of one Geraldo to see if Geraldo and Claudio still had a disagreement. And the reason he was allowed to testify, the reason that they had a disagreement was because it's sort of unclear, but either the morning before or the day before, Claudio had gone to speak to Geraldo, saying that Geraldo was disrespectful to his girlfriend, and that during this conversation, Santos, who was with Claudio, punched Geraldo. And Geraldo was put on to confirm that he was struck by Santos. In this court, in Santos' case, this court found that such testimony was irrelevant and should not have been admitted. Usually a prior bad act has to relate somehow to the offense. For example, the case inside my brief, wife and a boyfriend.
The prior bad act by Santos.
Right.
So why is it prejudicial to your client?
Because again, it's showing, I think the prejudice here is even clearer than before, that because it's showing that they were working together. Claudio was talking to Geraldo, and Santos was there with Claudio, and during this conversation, Santos, it looked like acting for Claudio, struck Geraldo. I mean, the problem was between...
Isn't that why the prosecution claimed it was relevant? It's because it showed that Santos has Claudio's back, and if somebody disses a buddy of Claudio, then Santos is there to take care of it.
Well, I mean, first, this court found that it wasn't relevant in Santos' decision, saying that it didn't, relate to the offense. But, I mean, just because that they...
But can you have it both ways? Can you say it is irrelevant and yet prejudicial?
Well,
To you, to your client?
Yes, because it's showing that Claudio and Santos were these violent people. You mean, are you asking me why it's prejudicial?
Right. Why is it prejudicial to your client, since your client didn't do the slugging? That was Santos who did the slugging.
Because it showed the jury that they were working together, that they had this tendency for violence. And remember,
was it admitted against Santos at the trial, at the joint trial?
I don't think there was a distinction made.
Wasn't if I'm sort of going from this case, but was the theory of the judge that what she said to the jury is that you can consider that evidence as to whether there was a joint venture between the two of them? So presumably it would have been admitted against both.
Yeah. So that's why it was admitted. But based on, like, for example, the cases cited in my brief, there's no relation to this punching incident that happened at some other unrelated time with the present offense. It didn't show that they were going to do a drug deal. It didn't show that they had a gun. It didn't show anything. All it showed was at some other time there was this violent confrontation involving the same two people, Claudio and Santos, and the jury is likely to take this irrelevant information and find that Claudio and Santos were again working together for a violent purpose. I mean, as I set out in the last argument I briefed, my 33-year argument, there was a lot of evidence showing that Claudio wasn't involved. When they pulled up to the scene, this is based on Marquez's testimony, and when they pulled up to the scene, Claudio said to Santos, "If you're going to rob that kid, don't shoot him." And then Santos said, "I'm going to rob the guy because he owes me money." There was a big question of whether Santos was acting alone or if Claudio was indeed a co-venturer. Also, Claudio got out of the car, but he didn't go to the site of the shooting. He stood around the corner during this giant traffic rush hour at the scene. So evidence that they were working together for this violent purpose at some other time could have been key evidence in the jury's consideration of Mr. Claudio's case.
Who supplied the gun? No, was it a gun or a knife?
It was a gun.
Yeah,
And
who supplied the gun?
Marquez said that Claudio gave Santos the gun.
Okay, so you don't have a joint venture?
Well, I'm saying that he withdrew. Well, first of all, Claudio denied even being there. But taking what Marquez testified, who was testifying under the plea agreement, taking what he said that Claudio gave Santos the gun, but that also when Santos was leaving, that Claudio said, "Don't shoot him.
Just rob him. Don't shoot him."
He didn't say don't. He didn't even say don't. If you're gonna rob him, like he left it. He
left it entirely to him.
And it was Santos who said it was owed money and said, "I'm going to rob the guy." I mean, the evidence mostly shows that there was going to be a drug purchase and that Claudio helped set up the drug purchase with the decedent.
Knowing that Santos was going to rob him.
Just leaving it to Santos, based on what Marquez said, leaving it to Santos. If you're going to rob him, don't shoot the guy.
So it sounds like pretty good evidence of participation in a joint venture, at least for armed robbery.
Well, we contend that this was a withdrawal from
Well, did Claudio
any
go
robbery.
But when Santos got out of the car, Claudio went with him, right?
He got out of the car, but he didn't go to the shooting scene. He stood around the corner.
But he, I mean, he's done all he needed to do. He gave him a gun to perform an armed robbery. What? How do you withdraw after? I mean, in order to withdraw from there, don't you have to say, "Give me the gun back"?
Well, he told him. I mean, he didn't take the gun back. He told him not to use it,
Or not to shoot
not to shoot.
the victim. Didn't tell him not to
Don't
use
go
it.
shooting them.
But that was the only theory of murder on which your client was convicted, correct? Felony murder?
Right. Yes. Only
On the armed robbery?
based on the armed robbery. Yes.
Perhaps you can clarify something for me. This question of whether there should have been a jury instruction on second-degree murder with respect to your client. What was his counsel's position on that, and is it clear from the record?
It could have been clearer. During the charge conference, counsel said, I didn't include first or second degree written instructions in my request. I expect that the court will give the standard instructions. And then I think it was the next day before the charge, the district attorney said there could be a chance of assault with intent to rob or larceny. Therefore, there should be a second-degree murder instruction.
Second-degree felony murder, yeah.
Then the judge says something like, I didn't get any requests for that, and I'm not going to give it, and then I'm only going to give first degree as to Claudio, and then counsel says, I object.
Which counsel?
Claudius.
Claudio's counsel, without saying anything more than that.
But your position, I take it, is that given the timing, that the objection is clearly about not giving the assault with intent to rob second-degree felony murder.
Right, yes. And we contend that there should have been, based on armed assault with intent to rob. I think that armed robbery and armed assault with intent to rob are very close offenses, but the Rivera case I cite in my brief, in a footnote, really goes through both of them. In Rivera, it was an armed robbery while masked, and they go through the difference. Oh, in that case, there was both the armed robbery and the armed assault with intent to rob instruction were given. Therefore, there was a chance of first-degree felony murder, second-degree felony murder. The difference is that if the predicate offense doesn't carry a possible of a life sentence, then there has to be a second-degree murder instruction. So in Rivera, it involved a robbery of a convenience store where the clerk wouldn't give up money and eventually was shot. And this court said that the difference between the two offenses, armed robbery and armed assault with intent to rob, is for armed robbery there has to be actual force or actual fear of the decedent.
But in Rivera, they didn't, if I'm remembering correctly, and I may not, but there was no proceeds from the event. In other words, here you've got this necklace that comes away.
Right.
That was clearly the victim's necklace. In Rivera, there was nothing like that, was there?
But here, it's a question of when or how or even if the necklace was stolen. I mean, the decedent was found with a cell phone, a large amount of cash, and drugs on him. So, in fact, what the district attorney said during the trial was that they could find that there was nothing taken. But the witnesses said that after the shooting, they saw the decedent running from the scene and then falling, and then men going up to him and bending over him. So we contend that if the cross was taken, it may well have been taken at that point and not, during the shooting or during this original incident, especially because he was found with a lot, I think over $1,000 in cash and drugs and cell phone and some other things. So it wasn't clear that there was a robbery or when it occurred. So at least had to go to the jury with this second-degree murder possibility.
If there was no doubt that the necklace was taken, and if the Commonwealth had charged assault with intent to rob, is it your view that he must be found not guilty because there was things stolen?
I'm sorry, that he'd be found not guilty?
Are you saying that you can't be found guilty of assault with intent to rob if there's an actual robbery, if there's an actual theft?
No, I'm not saying that. I'm just saying that in the Rivera case, there wasn't an actual theft. So,
Didn't the judge suggest that? That because there wasn't, at least it looked like there was an actual theft, it could not be assault with intent to rob?
I don't recall if the judge
maybe I'm
said
just
that.
misremembering.
It just seems to me that it's not.
I'm not saying that. I'm just saying I thought maybe she said something like that.
I don't think it's relevant that whether something was stolen. It depends on the force and the fear of the person shot. I see that my time is up. Thank you.
Thank you. Good morning. May it please the court. I'm Robert Bender, Assistant District Attorney for Middlesex, and with me is Elizabeth Dunnigan, who tried this case for the Commonwealth.
Mr. Bender, focusing on the subject that we just left, which is the jury instructions, shouldn't the judge have instructed on second-degree felony murder in these circumstances?
No.
Why not?
Well, first of all, this court's case law is that where the felony murder rule is being followed, and the felony that is the predicate is one which supports first-degree murder, armed robbery supports first-degree murder as a life felony, it's an inherently dangerous felony, that there is no second-degree instruction because it would be really just leaving it up to a jury to say, well, it was armed robbery, felony murder, but, we get to pick whether it was first or second degree with no basis to making that distinction.
That's not what the question is on the evidence whether there is another offense that has a less than life sentence that should have been instructed on.
No, the answer to that is no.
Because?
Well, a couple of reasons. Number one, the armed robbery was a completed offense. There was no evidence that the necklace was not taken during the course of the robbery. What was argued during the jury instructions about that was whether it's a robbery if the necklace was taken after the shooting of the victim. And that is a position that the court properly rejected, that the taking can follow the use of force and here the shooting, and that doesn't mean it's not a robbery. So that's the basis that they were saying that this might not be a robbery. It wasn't a question that there wasn't something taken. Now, not everything was taken from the victim, but I don't think that that's ever been a basis for saying it's not a robbery. What was taken was of considerable value. There was testimony that the defendant, Mr. Santos, was trying to sell it for 50 bundles. 50 bundles, and each cost $50. So it was a considerably valuable piece.
Are you suggesting, I'm not saying the jury has to find assault with intent to rob, but are you suggesting that for the crime of assault with intent to rob, there cannot be anything taken?
No, I'm not suggesting that either. But I'm saying that where we look at assault with intent to rob, this gets back to really the discussion that was in the Rivera case. In Rivera, the defendant was charged in a felony murder with armed robbery while masked. That was why he was indicted. And during the course of that trial, it was determined, and the court so ruled, that the required finding was entered as to the robbery because nothing was taken during the robbery. And the judge said, I will reduce the indictment for armed robbery to armed assault with intent to rob because there was nothing taken. Then the question came in then as far as what are you going to charge on the felony murder aspect. And there the judge did something that is really reflected in the way our statute on murder is written. He said that I'm going to have as the predicate felony for first-degree murder an attempt to commit an armed robbery. And that's a life felony. It's not, armed robbery is a life felony, but the felony murder rule says that if you attempt a life felony, it's also first-degree felony murder. And so the court on that basis gave first-degree felony murder, even though there was no evidence that anything was taken. And on the basis of the assault with intent to rob, he gave second-degree murder because that is a 20-year felony and it can carry a second-degree charge. But that's not the case here. In this case, the Commonwealth was not directed out on the robbery. The Commonwealth was asked what would be the case if there wasn't a taking. And they speculated, well, the charge would be assault with intent to rob. But the defendant, Mr. Claudio, did not bite. and say, I want to have that possibility and make an argument that I should have a second-degree charge on that basis. And in fact, if one looks at the strategy or the tactic here, which is very clear from the defendant's closing statement, he got up and literally said to the jury, I'm charged with felony murder for my participation in an armed robbery where I told the guy not to shoot him. My co-defendant, Mr. Santos, ladies and gentlemen of the jury, is charged with murder by deliberate premeditation, which I'm not a participant in, and felony murder and manslaughter, because the judge was willing to give a manslaughter on the theory that somehow the resistance of the victim might have been a basis for provocation, and therefore there was a basis there. That instruction was not given for Mr. Claudio, because Mr. Claudio said, I want it, but the judge said, you're not going to get it. I don't really see how your role in this, you were provoked. The provocation went to only to the shooter if there was any provocation at all. Whatever the reason, the judge didn't give the instruction of manslaughter for Mr. Claudio. That's what the objection was that Mr. Claudio had to these things. And he was therefore able to stand in front of the jury and say, you're looking at me for first-degree murder for just standing there in the neighborhood, and you're considering manslaughter or second-degree murder for this other guy?
Where Chapter 265, Section 1 says that the jury shall determine the degree of murder.
Yes.
And in felony murder, at least as we understand it now, there's only one choice. Why isn't it more consistent with what the legislature intended in Chapter 265, Section 1, to always give, at least where armed robbery is the predicate felony, to give assault with the intent to commit robbery as a choice for the jury consistent with its authority under Chapter 265, Section 1?
As reflected by what the judge did in Rivera, where there was no robbery because that charge wasn't there, the judge gave, I say very wisely, the attempt to commit an armed robbery to get a life felony for the first-degree charge, and then said on the basis of the indictment for armed assault, I'm going to give the second degree. But there was a basis in the evidence for what the judge instructed. This court has said repeatedly, and it certainly has reviewed the question, but as recently as 2011, I believe, in Commonwealth versus Stokes, according to my brief, they repeated what it said in Paulding, that that's not going to be the rule. In these felony murders, if there is no felony that supports second-degree murder, then there is only a requirement that you instruct on first-degree murder. That's the law.
Well, I mean, the felony doesn't have to be charged.
No, the felony does not have to be charged, but there has to be a theory in the evidence for the lesser felony that is a predicate.
There was no theory in the evidence here on assault with intent to rob.
There was no reasonable basis to say that there wasn't a robbery.
Well, let me give you this hypothetical. Conceivably, there could be a first-degree murder based on only deliberate premeditation.
Yes.
In which the defendant is on videotape and also in the presence of 200 people, in which he says, I am going to kill you tonight, and I'm going to do it with this gun. And then 10 minutes later, shoots the person. There's absolutely no question that is a deliberately premeditated murder. And yet, in those cases, we always instruct on malice.
Yes.
We always give the jury a second-degree option because the statute requires it.
I respect the questions about whether this felony murder rule that we have adopted in practice in this Commonwealth for as far back as I can imagine is the law. And that's not a challenge that the defendant has brought before you. If the court wants to look at this under 33E, I would suggest that we brief it and provide some reasons of whether we should change what has been settled law in this Commonwealth. But that's settled law, and I think the judge gave her. Now, what?
It's settled law. I thought that there was case law which said that where there is a viable second-degree felony, and if the defendant requests a second-degree felony charge, he's entitled to it.
First of all, the defendant did not request it. And second of all, there wasn't a viable thing. There is, as a matter of law, yes.
Now,
One can come up with felonies.
Let's go through each of those. If you had indicted this defendant, Mr. Claudio, for assault with intent to rob, are you saying that he'd be entitled to a directed verdict?
No, I'm saying that if that was, he was indicted for that, and we intended to show that, and even if we showed there was a taking on that basis, according to Rivera, he would be entitled to the second-degree theory, because that's a theory that we put before the jury as a predicate for the felony murder. In this case...
So the question is whether you put it before the jury or whether he puts it before, or whether he, I mean, I'm confused.
The evidence.
Before you said there was no basis in the facts for a second-degree finding, and now you tell me, no, there is a basis. That assault with intent to rob is a viable felony, albeit uncharged.
No, I'm not saying that, Your Honor. I'm saying that if we had indicted him for assault because we felt that that's what the evidence showed, and that was what we put forward, then there would be a basis to treat it as a second-degree felony murder. Much as the arson cases that frequently end up in someone's death, arson is a second-degree, only supports second-degree felony murder. We don't bring a first-degree charge when the felony is arson. We can't do that, even though 265(1) says you kill someone in the course of a felony, you know, the degree of the murder shall be determined. I mean, it does cut both ways. We're restricted to what the law allows as a basis, and so is the defendant. What the argument in this case was about why I'm not guilty of armed robbery is, A, I didn't participate in the crime, and B, I didn't share the intent that there be a robbery. Now, what I argued in the brief is the difference between an armed robbery and assault with intent to rob is whether there's a taking. It's not whether or not the Commonwealth has shown there's an intent to rob. The intent to rob is an element of both crimes, and that's why, if that was the problem, which is not the problem in Rivera, there wouldn't be a reduction at the end of the case.
You would have to. I think your argument would be that in order to get a second degree on assault with intent to rob in this case, you would have to have the law be that assault with intent to rob is a lesser included offense of armed robbery, and whenever you have armed robbery, you have to get the charge of the lesser included offense.
I would agree. I would agree. As far as I understand you, I agree that. But the thing is our rule on lesser included is not that you get every lesser included offense regardless of the evidence. You have to show that there's a basis for acquitting you on the greater and convicting you on the lesser, on the element that distinguishes them. That's not what happened here. Here, the element which distinguished the two crimes is a taking. And there was no basis in the evidence to argue there was no taking. In fact, none of the defendants argued there was no taking. The closest they came to arguing is there's no robbery when you take after the shooting, which as a matter of law is incorrect. But it's not a factual basis for ruling anyone out.
That goes back to Justice Pina's question. There could be no basis in the law for anything less than premeditated murder, but you still get a second-degree instruction.
We do. And I can't speak for the court. I'm not a member of the court. But I do know what the law has been, and that's the way it's been.
You'd have to go pre-Paulding to get there.
Yeah, at least. Now, I want to address a couple of the other things that were mentioned.
You were saying that there was no request here for an instruction, and your brother says he didn't ask for it, but then when the ADA mentioned it and the judge said, I won't give it, he objected. Is that your understanding? I don't think, first of all, that the Commonwealth asked for it. The Commonwealth went through a discussion similar to we have as to what is the law here and how does this law work. Not that there wasn't any evidence of a taking. And you know, this is something that can happen in the course of a charging conference, is people ask hypotheticals and suggest. Just as the defendant said, hypothetically, don't I get manslaughter because my co-defendant says that he was provoked? The judge was really, I think, bending over to give that instruction, because the judge also cited that in committing an inherently dangerous crime like armed robbery at gunpoint, the fact that the victim might resist you when you pull a gun on them is not provocation by the victim. And therefore, there is no basis for the manslaughter. But the judge gave it anyway. Was the,
maybe you've said this. I know the defendant was found guilty only of felony murder, armed robbery. Did the judge charge as a co-venturer in the deliberate premeditation?
I couldn't hear the end, Your Honor.
Did the judge charge first-degree deliberate premeditation as a co-venturer for your client?
No. Premeditation was only as to Mr. Santos.
Okay.
And the only deviation here from the Zanetti pattern is that the judge did instruct that the theory is that Mr. Santos is the principal, the person who did the shooting, and Mr. Claudio is a joint venturer. Now, as far as the argument that without a conviction of someone as the principal, there can't be a conviction of a joint venture, I believe the law is as long as there's proof that there was a joint venture, any joint venture can be convicted independent of the principal. But there has to be evidence that there is a joint venture to convict someone as a joint venturer. Otherwise, you have to prove that there is a principal. Somebody had to do the crime if you can't show there's a joint venture. Here there is a joint venture. The evidence the court reviewed with the defendants is very clear. I just, summarize not only what it was, that Mr. Claudio arranged for a car. He got Mr. Marcos to drive them. He got a phone from Mr. Marcos, although the court's prior opinion refers to it as Claudio's phone. The testimony is that it is Mr. Marcos's phone that was being used here in the car and used by Mr. Claudio. And that becomes important as to how it was that the Commonwealth was able to convince Mr. Marquez to talk when they interviewed him the second time. They said, we have calls here. You told us before when we talked to you that your car and your phone, Brooklyn, he called them, Mr. Claudio had. A little different than the question, or the little different response than Mr. Santos gave in the 45 minutes of his statement, which was not suppressed. In that 45 minutes, he was asked repeatedly, did Brooklyn, did the Claudio have this white car? Because that's what witnesses thought they recognized at the scene. It was people pulling away from running up the street, School Street, and getting in a white car and leaving. So they were very interested in people having a white car. How did they know to ask this of Santos and Claudio and Marquez? Because when they went out looking for Mr. Santos the day after this crime, based on Mr. Pacheco, the guy who knew him from the prison, said, I was there minutes before this guy was shot. I didn't see the shooting, but I saw Santos standing there at the pharmacy. Based on that, they went to find Santos and asked Santos, well, you were there, right? Did you see anything? This, by the way, is not accusing him of committing a murder. This is accusing him of lying to us when we have someone who knows you and says you were there. And he has a pretty good reason for saying, I know you, and why you were there, and what could be going on. And I know that you know Danny Rodriguez, Mr. Santos, because Pacheco said that's who you introduced me to buy drugs. This is what that interview was about. This is the thing that is somehow prejudicial to Claudio. Now, that 45 minutes was properly introduced, and what was said afterward was not properly introduced. It doesn't prejudice Claudio at all because, in fact, it turns back to his main defense, which is, I didn't really even participate in a joint venture. This guy, Santos, went down there by himself and he killed this guy. He didn't go down there literally by himself. He went down across the street from the pharmacy where the buildings are set back somewhat, and he moved with this guy that I called to meet us. He moved him around out of sight of the busiest street in Lowell so that he wouldn't be standing there on the sidewalk. And I'm around the corner. I don't really know what this testimony is and what the precision is. Nobody testified as to, well, I saw Claudio here and I saw Santos there. They were able to find where Santos and the victim were based on the blood trail. They saw where the blood started, and they found where the packets of heroin were that the victim supposedly had scattered on the floor and on the ground, and they found evidence that this looks like where it is, and they could see how close that was to the street. Nobody of all the witnesses were found said, I saw the shooting. What the people said is, I saw people running across the street from the north side of Pawtucket to the pharmacy side in the middle of the block. And the first guy in that line, that race, fell, and that's Danny Rodriguez, we suppose. He's the only one that anyone thinks fell. And he fell down in the parking lot of the pharmacy, the pharmacy building then being between him and the corner of School Street. And people saw these two people run up School Street, up the hill, away from the pharmacy and away from the crime scene to a white car. And Mr. Marquez says he was driving that white car. He waited for them, and the two people that got in that car were the two people that had left 6 minutes earlier.
Mr. Bender, you only have just about a minute left. So tell us why the reversal in Santos's case shouldn't strip the Commonwealth of the basis for Claudio's found.
Well, the main reason that Mr. Santos is getting a new trial is because his statement was continued after he invoked the right to counsel. The second thing that was cited as a reason is because Olga Gonzalez, who was the sister of Mr. Claudio, said that, yes, Mr. Claudio came to my house immediately after this, given the time of it. He came in the white car. He came with two people who I identify as Marcos and I identify as Santos. And he told me, my brother tells me, I told, the jury didn't hear exactly, but he actually named Santos. But the jury heard that my brother came and told me that I told the guy, don't shoot the kid. That statement came in. The court found that wasn't, despite the Commonwealth's argument that this was trying to get her to help them, to give them a place to stay for a few hours, maybe get a change of clothes, get themselves together while the police are streaming around the neighborhood looking for something. The court found that wasn't in furtherance of the conspiracy. Therefore, it was a statement of Claudio. Now, Claudio's statements are admissible against him. They may not be admissible against Santos, but that's why the error about Santos doesn't really affect Claudio. And Claudio also now has another witness besides Marquez to say, I told the defendant, Santos, not to kill him, not to shoot him. So he didn't even object to it coming in. And it didn't harm him. It helped him.
Mr. Bender, your time is up.
Thank you, Your Honor.
Thank you.